As Neha said, my name is Sarah Pace, and I am a staff attorney and clinical supervisor at the Northern California Innocence Project. We are located in Santa Clara, California, which is close to San Jose. I imagine we have people tuning in from like all over the country, but yeah, we are in the northern part of the state of California. And so I want to talk about a couple of things today. I want to tell you about what it is that I do, what the Northern California Innocence Project does, and also a little bit about how I got to be where I am right now, and a little bit about the history of innocence work, the innocence movement. So just starting off with our mission. So NCIP's mission is to promote a fair, effective, and compassionate criminal justice system and to protect the rights of the innocent. And you may be wondering, how it is that we do this. So we have sort of three main pillars, and we've sort of recently added on a fourth. But those pillars are exonerate, educate, reform, and the last pillar that is sort of a burgeoning area for us as an organization is reentry. And I will go through all four of these tenets today in my presentation. But that's sort of just a framework for how NCIP exists as an org. So I want to talk a little bit about the origins of innocence work. And so I feel like this audience probably has a good understanding of the criminal legal system. And I realized before that my slide said criminal justice system, but actually we tend to use criminal legal system because there can't be any justice when you have the over incarceration of Black and brown people and when you have innocent folks going to prison, right? I kind of wanted to explain like where the Innocence Project kind of lives in this ecosystem of the criminal legal system and how it came to be. So with the passing of the 13th Amendment in 1865, at the end of the Civil War, you sort of have this huge sea change, right? So slavery has been abolished on the books, but the 13th Amendment with its carve out that says indentured servitude and slavery are allowed for people who are convicted of crimes. And that loophole basically allows for slavery to exist by another name. And that is why, we sort of have this system that we have today, right? So essentially the oppression and the continuation of white supremacy can exist because there is this loophole in the amendment. And so you have basically a time in the US history where we're going through Reconstruction, and this idea was that with the end of slavery, the sort of country would change over. There would be a lot more rights and just sort of better living for Black people in this country, but that just wasn't the case. And instead, we had a rise of lynchings, right? And a woman named Ida B. Wells, who went on to co-found the NAACP, sort of used innocence work to combat lynchings. And that is sort of one of the first kind of examples we have of innocence work. Essentially, what Ida was seeing was that people just assumed that the men that were being lynched, Black men, 75% Black men being lynched, were guilty of a crime, right? And that's why they were being targeted like this, when in fact, actually, they were innocent. And so she would use her investigative journalism skills to show that to the world, because there was no chance that there was going to be a fair trial during this time, because the juries were made up entirely of white men who harbored racist beliefs. And so she went out into the public using news outlets to sort of explain that these are innocent men. And that was a way that she was able to garner sympathy and attention and try and make some change. Another sort of titan of the innocence movement is Thurgood Marshall. And many people know him as the first Black Supreme Court justice. But before that, when he was working at the NAACP, he was litigating innocence cases. And he was going out and finding defendants who had been wrongfully convicted and litigating their cases all over the South. And that was in the 1960s. So long before, I was born, before the Innocence Project really became a thing, there were some really important people, particularly Black people in this country, who were doing this work before us. And I just want to take a moment to sort of recognize that. I think all of you heard from Rodney Roberts earlier today, and he is an exoneree with the Innocence Project. And so I just want to sort of clarify the difference between the two. So in 1992, we have these two great lawyers, Peter Neufeld and so there's two men right here in the picture, and Barry Scheck, sorry, I forgot his name for a second. They go on to found the Innocence Project, which is based in New York. It's the original Innocence Project, and it's based entirely on DNA exonerations. So these are cases in which a person was wrongfully convicted, and they were able to go back in these old cases and find physical evidence that had not been tested for DNA at the time, but years later they can test it, and the DNA doesn't match the man or woman who's sitting in prison, and so they can help them exonerate that way. And I can talk a little bit more about that. So the Innocence Project out of New York is specifically doing DNA types of cases, but it's catching on, right, that there's actually a lot of people in this country who are wrongfully convicted, and they're not just in New York, right? They're all over. And so basically, lawyers all across the country and now all over the world start their own chapters or their own branches of the Innocence Project. So my particular branch is the Northern California Innocence Project. We were established in 2001 at Santa Clara Law School, and we are one of 72 now Innocence Projects worldwide. So like I said, I was asked to talk a little bit about my journey to this work. I actually knew I wanted to be a lawyer from a very young age, which may resonate with some of you watching this. My dad is an attorney, and while he didn't do any sort of social justice type work as an attorney, he was an intellectual property attorney. I did see him sort of carry out social justice in his downtime. So I sort of saw him serve as a servant to the community when people would come to him just asking him for advice on writing their will or what they should do because their cousin got into a car accident and wondering if they have a personal injury lawsuit there. And so those sort of aspects of him being an attorney really spoke to me, right? I sort of saw him as this critical resource for the community because he could speak the language of the law. And it really is its own unique language. And so I knew from like the time I was 10 that I really wanted to be a lawyer. And so, in college, I majored in political science, thinking that was sort of the best kind of setup for a career in the law. But I think my advice would be, if you are considering law school and you're, sort of in college now, I would say major whatever you want. At the end of the day, you still have to go to law school. So I mean, it's good just to sort of have a background in something that you're passionate about, because you're going to learn all the tools you'll need to be a lawyer in law school and then working as an attorney. So after I graduated, I was like, well, I really want to check this out, see if I really like this. So I went and worked at a plaintiff side firm in New York, which gave me some really good exposure to like what it means to actually be a lawyer on the day-to-day, because it's not just all like courtroom drama. And that was good. It was very solidifying that this was what I wanted to do, because I really felt like I could help people the best by being an attorney. So I took the LSAT and eventually got into Berkeley Law, which is how I ended up out here in California. And while in law school, I had the privilege of working at the Youth Defense Clinic, which is located at the East Bay Community Law Center. And we were representing youth who were justice impacted, and they were going through the system and they were going through juvenile court proceedings. And so as a student, I got to have my own clients and represent them in court, and get to know them and understand their issues and why it was that they were having trouble and why they were sort of getting wrapped up in this system. And it was really meaningful work, and I felt like I was making a difference, and especially for youth, right? Because the potential is endless, right? The future is theirs. And so to sort of to have a system that would completely cut off someone from achieving their goals from stifling their future is just incredibly sad and on a whole different level. And so I was very, very called to this work because of the experience that I had working at the clinic. And so I went on to work at a firm, and while I was there, I went and did a lot of pro bono work, specifically working with prisoners in Louisiana who had been convicted by non-unanimous juries, which might sound like a really crazy thing. But basically in Louisiana, it was perfectly legal to have only 11 or 10 jurors say, yes, convict, while 2 still hold out and say that there's reasonable doubt of this person's innocence or this person's guilt. And that all stemmed from the stuff I was talking about earlier, right? So when slavery was abolished, there was this void for labor in the South, particularly. And so the white people in power wanted to make sure that, the status quo remained and that they could still continue to continue white supremacy and oppression of Black people. And so in order to allow for slavery to continue by another name, they made it easier to convict Black people by passing laws like non-unanimous juries, right, which just makes it that much faster to find someone guilty. And then through this thing called convict leasing, prisoners would then be sent to the plantations to work on the fields. And so it was essentially just all one big cycle. And so eventually that law about non-unanimous juries was abolished. And so at the firm, I was able to go in and represent prisoners who had been convicted by those types of juries and go back and file motions to try and get them a new trial or a new prison sentence or to get them out. And that work really sort of cemented for me that I really wanted to do post-conviction work specifically in the criminal legal world. And so when a position at the Northern California Innocence Project opened up, I applied. And I'm happy to answer any questions about my career trajectory and this work at the end. I'm hoping to save time for Q&A. So now I want to get into sort of the nitty gritty of what it is that I do and what we do at the Innocence Project. And I'm so glad you got to hear from an exoneree because we work for them. We work for our clients, and it's their stories that really matter the most. But I'm happy sort of to provide you with kind of the lawyerly side of the work. So the first thing that happens is potential clients write a letter. We get thousands of letters every year from all over the state of California. And when we get the letter, we sort of need to assess a couple things. So the first is this within our jurisdiction? We can't represent everyone all over the state. We just don't have enough attorneys or resources for that. So our cutoff is San Luis Obispo County and north. And so as you can see, that is more than half the state, but those regions are sort of less populous than the southern part of California, which includes LA, which is giant. And so we have sister organizations down in Southern California who are taking on those cases. So the next thing we look for in these letters that we receive from potential clients and incarcerated folks is, what does it mean to be innocent? So we have to sort of understand, we can only represent people who are actually innocent. And through the letters from potential clients, we sort of have to see if they are eligible. And so I'm going to do an exercise right now where I'm hoping people can sort of interact with me a little bit. I'm going to go through a couple scenarios, and you're going to tell me if this is a case that we could possibly take. So the first one is, I was in the car, I drove them there, but I didn't do the crime. So this is a potential client who's writing to us, explaining to them why they think they're innocent. And it's up to us to decide whether this is a case we can take on. So I guess if people want to, I don't know if they can yell out or you can signal with your hands.
Yeah, feel free in the chat. You guys can write, and also you can react with the thumbs up or the thumbs down button.
Perfect. Yeah. So, okay, thank you. Yeah. So if people think that this is a case we can take, I guess say thumbs up, and if not, thumbs down, or yes or no, either work.
Okay, I see one thumbs up right now.
Okay, great.
And one thumbs down too.
Okay, Okay.
Yeah, I
Cool.
think
So
or split.
we're split. Okay, that makes sense. This is kind of a tough scenario. So basically, this is not a case that we can take. That is the short answer. The reason why it's complicated, though, is because he says, the potential client says in their letter that, they didn't do the crime. But there's this thing in the law called accomplice liability. So basically that when you are part of the execution of the crime, while you didn't actually do the robbery itself or whatever it may be, but you drove the people who did it, that technically means that you're guilty under the law. And that's not a case that we can take. All right, let's try another one. Okay, I did it, but it was in self-defense. Is this a case that the Innocence Project can take?
Okay, I see one thumbs up right now. I'll let a few more people react. Oh, two thumbs ups.
Okay.
Yeah, most people are, oh, okay, we got one no, but everyone else I see is saying yes.
Okay. Okay. So unfortunately, this is also not a case that we can take because we, again, are looking for people who have absolutely no action associated with the crime. And so just definitely did not do it. And while self-defense is a good way to defend yourself at trial and sort of show the jury that while, yes, you did it, but you had a good reason for it, that your life was in danger, on our end, that isn't going to be enough to help us get you out of prison. And that should have been a defense that was brought up at your actual trial and not after you were convicted. So unfortunately, yeah, we cannot take this case despite it being very righteous. Okay, my sentence is excessive. Is this a case that the Innocence Project can take?
Okay, I see two no. Oh, wait. Yeah, I see two no's. Let's see. I think most people are saying no at the moment.
Okay, yeah, that's exactly right. Again, extremely righteous, and I think there is a lot of good work now about sort of sentencing reform, and it sort of seems to be in the public dialogue. And there are some great organizations that do that kind of work. It's called resentencing, but we don't do that. And while resentencing can be a useful tool for us sometimes, it always has to kind of come from the original point, which is that our clients are actually innocent. And so if they're writing to us and they're only saying that their sentence is excessive, there's no underlying innocence claim. And that is where we always have to begin. Okay, and the last one. I wasn't there, I didn't do it. Is this a case that we can take?
I think most people are saying yes.
Okay.
Also, again, for those that just joined, feel free to react with a thumbs up or thumbs down. Yeah, I think everyone's saying yes.
Well done. Okay. Excellent. Yes. This is certainly a client that we can take on. And so the next part becomes, how do we prove it, right? So moving down our sort of steps here in the process, once we get a letter from a client that's saying they're innocent, we will send them our questionnaire, which they fill out and send back to us. And we read over the questionnaire. We have one attorney on our staff whose entire job it is to read those letters, vet them, and send out questionnaires. She's our intake attorney. And once she thinks that, based on the questionnaire and the letter, that a case is viable, she will assign it to an attorney in our office. And that is when we commence our investigation. So that gets back to my question, which is, how do we prove someone is innocent, right? They've written to us, they say they're innocent, and it's not really enough just to tell us that you're innocent, right? Because we get thousands of letters, and there are so many people who are in prison in this state and who are innocent, but it's hard for us to sort of know just from a letter, who's being truthful and who isn't, and who actually has the evidence to back it up and who doesn't. So we often look for potential clients who have evidence already that they're aware of, or a witness that's important to their case that is willing to speak up about their innocence. And so I'll get to that in a second. But when it comes to the sort of evidence piece, physical evidence, we talk about forensics, right? And specifically DNA. And so I mentioned earlier that the DNA revolution came in the 90s when we discovered that we could take material found at crime scenes. That includes sort of actual autonomy, like your body, like material from your body, but also just like, you know, a sock or a piece of clothing, and test it for DNA and see if it matches the person who's been convicted of that crime. And if it doesn't, that's a pretty good reason to think that that person is innocent, and that the true perpetrator is still at large. We also have used advancements in technology to help exonerate our clients. There have been waves of different types of junk science that have kind of rocked the nation a little bit. For a while, law enforcement was doing this thing where they would compare a hair found at a crime scene to another person's hair, to like their suspect's hair under a microscope, like not testing it for DNA, but just comparing the two strands of hair under a microscope and being like, oh yes, these are similar enough. And the problem with that is that like it's so subjective, and hairs are not like unique enough such that like when you put them under a microscope, it's like a absolute match to someone else's hair. It was just kind of crazy. But this was being used to put people behind bars. There was another type of science where they used bite marks at a crime scene, and they would sort of compare it to someone's teeth. And they'd be like, yes, that's similar. That must have been this person. And so the Innocence Project was responsible for sort of going back and showing why this science was absolute junk and couldn't be the reason that someone was convicted. Sometimes we're met with a scenario where there's no physical evidence left from the crime scene. And so then we're pretty much reliant on witnesses, right? And so I mentioned earlier that sometimes potential clients will write to us and say, hey, I have a witness who knows something about my innocence. They're willing to speak up now, but they weren't willing to speak up earlier during my trial. So we'll go talk to them. Sometimes we have witnesses who tell us that they actually lied at trial for reasons that for many reasons, and I can talk a little bit about that later on. We hire private investigators to go and find new witnesses and talk to them to see if they have any information. A lot of our work is just turning over every single possible stone. Other ways that we can show innocence is going back and looking at what law enforcement was doing. You know, there are definitely lots of issues with law enforcement in this country, and we have seen many, many cases in which a police officer has lied on the stand that led to the wrongful conviction of a client, or the prosecutor or the police officers withheld information that was exculpatory, which basically is information that showed our client was innocent and never turned it over to that client or their defense counsel at trial. And that is unconstitutional. And so we can sort of help show innocence that way. Sometimes it comes down to our client's trial lawyer, their defense attorney, was acting incompetently at trial and just didn't do a good enough job defending them. And we can show that and help get an overturn of conviction that way. And sometimes we end up just trying to find the true perpetrator. You know, that is also sort of a way to show that your client is innocent if you can find the true perpetrator. But that is also very, very difficult, especially when you don't have the resources and the same sort of channels available to you that law enforcement does. So I just wanted to sort of go over the numbers a little bit. I think honestly the most kind of like poignant number here is the number of letters that we receive every year, which is 1,688. And we currently have around 67 active cases, and we only have 4, lawyers in the office. So we're definitely very busy. So the final step in the process of our cases is litigation. And so we've done all the investigation, we've overturned every possible stone, we've gathered up any possible evidence of innocence that we can find, and we put all that together in a motion. But before we file, we like to go to the district attorney's office. And so I want to make sure I'm sort of like explaining all of this. It's like law 101 here, but in a criminal case, there's two sides, right? It's an adverse system and they're against each other. One side is the district attorney, also known as the prosecutor, and these are elected positions. The DA runs the district attorney's office, and under him or her, there are lots of assistant district attorneys. And so we will go to that office in the county where the case came out of, where it was originally tried. And we will tell them that, you know, we found evidence of innocence in a case that you prosecuted, and you might be interested in this. And hey, like, do you want to make it right? Do you want to admit that you made a mistake? And do you want to help us get this person out of prison? A lot of district attorneys' offices across the country have created what's called a conviction integrity unit. So that's a specific unit within the office that's whose sole job it is to go back and look at these old cases in which a person may have been wrongfully convicted. And so oftentimes we'll go to that unit specifically. And if they agree with us, sometimes they do their own investigation. Sometimes they just believe what we found to be true. They'll concede, right? And that'll make the process go a lot faster, because while we still have to file before the court, having the district attorney be like, yes, you know, this was wrong, this person is innocent, will go a long way before the judge. Can anyone, maybe in the chat, sort of offer maybe why a district attorney may not want to do that, may not want to concede? Let me know if you see. I'm not sure if I see any answers in the chat. It's okay. I don't want to put anyone on the spot.
I don't see anything yet, but I guess my own guess would be maybe they have a stance that they want to maintain of being hard on crime. I think that's something I hear a lot.
Totally, yes. That's absolutely true in certain counties. Because they're elected, right, they have to maintain their public appearance. And so, yeah, letting someone out of prison would be antithetical to a sort of tough on crime platform. I think another thing we see is a lot of pride, right? For a district attorney to admit that their office made a mistake sort of is a big deal, and also can alter how the public sees them. Maybe the public loses faith in their abilities. And so there's a lot of that involved. I think in the criminal legal system, there's also this need for finality and not undoing things that have already been done. That's why our work can be really hard sometimes, because we are really pushing up against that finality. The next thing we do, whether we get the yes or no from the district attorney's office, is we file what's called a writ of habeas corpus. Habeas corpus means like holding of the body in Latin, but it's basically just the term for the motion that we file on behalf of our clients. That's what it is. And we file it in the original trial court where the trial happened. A really weird thing about habeas law in California and a lot of the country is that technically, when you file this motion, it goes back to the original judge who presided over our client's trial. I'm curious if anyone can share maybe why that would be an issue for us and our client.
Feel free to unmute, raise your hand, or use the chat for it.
Is it also something similar to what the district attorney situation was, where they don't want to go back and say they made a mistake in the first case, or didn't think through the decision thoroughly?
Exactly. Yes, that's exactly right. So, you know, judges are even prouder and are even on more of a pedestal than district attorneys in many situations. And so for them to sort of go back to the trial that they presided over and say, well, I let this happen, I let an innocent person go to prison, would be like a real big blow to them. And so it is frustrating for us because the bias is still there, a bias to sort of preserve their old decision. Oftentimes, though, our cases are so old that a lot of the judges that originally presided over the case are gone or have retired or whatever. But every once in a while, we come across this and we will ask to change judges to prevent that bias from coming through. And so the ideal next step would be to have an evidentiary hearing. And so we will file this motion, this habeas motion with the court. And if they think that our evidence is viable, they'll conduct what's called an evidentiary hearing, which is basically like a mini trial, but no jury, where we will present all of this new evidence of innocence and try and convince the judge to overturn our client's conviction. Now, if we lose, which happens, we will appeal to the next court above the trial court. So in California, it's the trial court, then the Court of Appeal, and then the California Supreme Court. And that's similar, I think, in every state in this country. So we will just sort of work our way up the system. If we lose at the state Supreme Court level, we will go to federal court. And eventually, although I've never been there, but could possibly happen, end up at the United States Supreme Court. If we win, our client is exonerated. And what that means is that the conviction is overturned and our client is in the same position they were in before trial. So essentially, they've wiped away the conviction, but the charges are still there. And so the district attorney can retry the case. And so I think this sort of gets back to sort of what we had been talking about earlier with why a district attorney might not want to concede. Similarly, if the district attorney has lost this hearing and the conviction is overturned, they might want to retry it just to sort of continue to prove that they were right the first time. And that can be very, very frustrating for us and our client, who's already sat through one trial, one evidentiary hearing, and now is going to be retried for charges that we just showed he or she was innocent of. It's a tortuous process. Oftentimes, the district attorney will sort of kind of let it go and will dismiss the charges at that point. But sometimes you have some pretty ruthless ones that you kind of have to keep charging forward on. I want to share sort of like a very cool fact that NCIP has helped to free 35 people in our time since we were established in 2001. And those 35 people have served a combined 525 years in prison. And we can never get those years back, but we can do what we can to get them out as soon as possible and then to make their life as pleasant as possible once they are out. And I'll talk about a little bit about that later on. So I talked somewhat about the causes of wrongful conviction when I was speaking about evidence of innocence, but I'll just go through them quickly now. One of the major causes is false confessions. And you might be wondering, like, how is it that someone could falsely confess to a crime? And I think from the studies and from what we know, oftentimes false confessions come out because a person has been interrogated by a police officer in a way that sort of results in them admitting to something that they didn't do. And so we see these kinds of techniques used where police will lie to a suspect. They will keep them in a room for hours on end without any water, without any food, without any rest. And in that kind of environment, you know, it's easy to sort of slip up and end up confessing to something you didn't do just so you could get out of there. And so we see that happen a lot. One thing that's really cool that we at NCIP have done is that we championed a law in California that prohibits police officers from lying to youth and using those types of techniques on people who are 18 and younger, because oftentimes false confessions are more common from youth, and we recognize that. I just hope that we can also someday get to legislation that prevents law enforcement from using those techniques on everyone, but it's a good start. Another cause of wrongful convictions is jailhouse informants. Jailhouse informants are people who are currently incarcerated during the trial of our client, and the district attorney, the prosecutor, and law enforcement will give them benefits to get them to speak out against suspects, against criminal defendants. And so oftentimes that ends up with jailhouse informants not being very honest because they just want to get what's good out of a deal, right? Whether it be a lesser sentence or money. And so oftentimes we see a lot of false testimony coming from jailhouse informants. Faulty forensics, I already talked about this a little bit, but about sort of the hair comparison and the bite marks. Government misconduct, I mentioned this too, but this is when, you know, the prosecutor doesn't turn over evidence of innocence, or a police officer, you know, hides evidence or, you know, destroys it. Sometimes we even seen law enforcement plant things on clients to make them look guiltier. So there's lots of examples of that in this work. Bad lawyering, as I mentioned, our clients' trial attorneys sometimes are completely incompetent, and their lack of advocacy at trial will result in our clients' wrongful conviction. And then mistaken eyewitness identification. And this happens very, very often. I want to do an exercise with you to sort of illustrate how mistaken eyewitness identification can happen. So if people want to just put in the chat, which of these pennies is a real penny? And you can just sort of put the letter associated with the penny. But one of these pennies is the real penny, is the perpetrator. And I'm curious which one it is. One is actually what a real penny looks like in real life. So just throw out a letter in the chat. Okay, Audrey, you think it's J? Yeah?
I hope it's J.
Okay, I got an I. Okay, any other votes? Okay, A, okay, D. All right, we got a large mix of answers here. M. I love how everyone's using question marks after their answers. I mean, imagine if you were sitting, you know, at a police station and asked to pick out a penny out of a lineup like this, right? Okay, so I'm going to reveal to you that none of these pennies are a real penny. Yeah. And I love using this example because you can totally see how you can end up picking M, and then M, you know, gets picked up by the police, and before you know it, like, M is incarcerated for something they didn't do, right? And so it's just human nature. But we as humans are not very reliable when it comes to sort of trying to remember what a suspect looked like, or what a person looked like at a crime scene. And this type of lineup is quite suggestive, right? Because in this case, I didn't put the actual suspect in the lineup, right? The real penny. And so I kind of tricked you into picking one that was certainly never going to be it. And we see this happen a lot. And we tried to pass legislation to prevent police officers from doing this type of thing. And there's other sort of tactics that we've suggested police officers use when they do these kinds of lineups, like, for instance, having it be double blind. So the officer who reported to the crime scene or is investigating the case is not the one that presents the lineup. That way they can't sort of persuade the witness into picking one. The person who's actually presenting the lineup knows absolutely nothing. And so they're just there to put the sheet of paper with the photos down. Always recording when a witness is given a lineup, so you can see exactly what their reaction was when they were given the photo array, when they were given the six-pack, which is what we call those, and making sure that the police officer didn't do anything to intimidate the witness as they were picking out the photo. So there's some things we're trying to do now, especially here in California, to correct that, and to prevent sort of biased or, you know, misidentification by witnesses. So that sort of speaks to a little bit about what we see in this world, which is called tunnel vision. And in the interest of time, I'm going to skip over this because I have a few more things I want to cover. But this sort of just speaks to the fact that, like, police officers are human beings, and you know, they have flaws, and so their own personal bias can come through, whether it be racial, but also just if they have someone in mind who did a crime and they just sort of seek them out and don't see any other evidence of anyone else, right? That's what we call tunnel vision. So I wanted to talk a little bit about the numbers. In the US, there have been 3,394 exonerated people, both by DNA and non-DNA, since 1989. 268 exonerations have occurred in California alone. 570 have been exonerated as a result of DNA testing. 14 years is the average length of incarceration of an exonerated person. That equals 28,770 years lost. And I think this statistic is really poignant. 50% of exonerees in America are Black versus them being only 13% of the US population. And this is a reflection on the fact that obviously Black people in this country are over incarcerated compared to any other group, any other racial group, but also that they are more likely to be wrongfully convicted. And so just let that sit in and sort of a reminder of how the system, I have a coworker who likes to say that the system isn't broken, it's all by design, right? So when I talked about the 13th Amendment and everything that was done to sort of perpetuate slavery and the oppression of Black people in this country, I mean, it's clearly still happening today. So I want to talk a little bit about educate, which is one of our pillars. And this is sort of where Gen Z becomes front and center. Like I mentioned, we are a nonprofit located at Santa Clara Law School. And so every academic year, we take on a group of future lawyers, and many of them are from Generation Z. And it's really meaningful to be able to supervise and mentor the next generation of lawyers, people who really want to do this work, want to be lawyers, want to be out there continuing innocence movement, criminal justice reform, whatever it may be, and allowing them to have this exposure while in law school makes a huge difference. We also do these types of educational programs like this, but I also go to high schools and I talk to students there. And it really amazes me how much people are aware of what's going on. Like I talked to a 7th grade class that had read Just Mercy by Bryan Stevenson, and I hadn't heard about that book until I went to law school, right? And it's really impressive and really gives me a lot of hope for the future. Another piece of what NCIP does is reform. So we're actually constantly in Sacramento pushing through bills that we hope will reform some of the criminal justice system, the criminal legal system here in California. And I mentioned the interrogations bill that we recently helped pass. And so we're working on other bills at this exact moment. And then the last piece is reentry. And so it's not just about, getting our clients out of prison, and we do that entirely pro bono, but it's also about helping them get situated once they're out. Our most recent exoneration was a man named Joaquin Syria out of San Francisco, and he served 32 years for a murder he didn't commit, so more than half of his life. And now he is home, and you can imagine that going into prison, when you're 20 years old and coming out when you're 52, a lot has changed. And so we are there to support our clients. I have a client who went in when he was 19, he came out when he was 41. And so, he doesn't even know what an iPhone is. He's never really worked like a full real job, never had a checking account. And so all of these things, we have to think about, things we take for granted, right? Getting housing, getting medical insurance. We also in California offer compensation for those who've been wrongfully convicted. So we'll help our clients get that compensation. And oftentimes they're entitled to damages through a civil lawsuit as well, which we help them with. So our clients are incredible people. They are so resilient. And when you hear from them, there's not a lot of bitterness. There's just an appreciation and gratitude for having been given this second chance. And they oftentimes want to help other people who've been wrongfully convicted in prison, which I find particularly inspiring. So I wanted to share some photos of them. I also wanted to share some artwork that we've received from our clients over the years. I mean, just incredibly talented. I want to draw your attention to the top right picture, which was done by Frankie Carrillo, who's actually running for office now in California, which is really amazing. But he sort of depicts the fact that he was like a little boy when he went into prison. That's the small foot. And then when he got out, he was a man, sort of that large shoe. And it's very moving and very inspiring. And so I wanted to share these with all of you. And that sort of brings me to the end. I know I didn't really leave. We have a little time maybe for questions, but also no worries. If not, you guys can reach me I'm happy to share my email address. I know Neha and Adria already have it, but yeah, please check us out on social media. Check out our website. We survive entirely on donations and grant funds. And we also are looking for volunteers and people to get the word out. So I definitely encourage you to check out our website and send us an email if you want to get involved. Thank you so much.
Thank you so much for speaking to us today. And I hope that people begin to get involved, and definitely take a screenshot of these links if anyone likes to join. If anyone would like to join or check them out, Audrey and I will be sending out a complete resource list with everything after the summit. But thank you again so much. If anyone has any questions, feel free to put them in the chat. It is time for our break, so I do want to let people take a little rest, get up and stretch. But if you do have any questions, anybody, please feel free to send them in the chat. And thank you again.